Gbagbo and Mr. Blé Goudé. The record will reflect that my fellow judges, comprising the full bench in the appeal, have joined the proceedings with us virtually. They are Judge Howard Morrison, Judge Piotr Hofmanski, Judge Luz Ibanez, Judge Salome Bosa. As some of you who follow the life of the court would have known, between the last time we were here hearing appeals on this matter and today, there have been a few significant changes in the life of the court. And we now have a new president who is always a member of the appeals chamber, and his first vice president also a member of the appeals chamber. So ordinarily that will result in the change in precedence, and also two judges whose terms have expired. But for purposes of consistency, we will keep the order of names of judges on the record as they've always been. With those little details out of the way, may I take the appearances now, beginning with the prosecution.
Good afternoon, Your Honours. Appearing on behalf of the prosecution are myself, Helen Brady, Senior Appeals Counsel, and with me today are Mr. Reinhold Galmetzer, Appeals Counsel, and Ms. Priya Narayan, Appeals Counsel. Thank you.
Thank you. And then defense team for Mr. Gbagbo. May I have appearances for the defense team for Mr. Gbagbo?
Monsieur le Président.
Ms. Naouri, Your Honor. Mr. Altit, coming in remotely.
Mr. Arteza, we can hear you.
Bonjour, Monsieur.
Good afternoon, Your Honor.
Alors, l'équipe défense est composée.
The defense team today is made up of Ms. Baron from Abidjan, Laurent Charot in the premises of the court, Ms. Naouri and Mr. Jacob, who are alongside Mr. Gbagbo, and myself. I am Emmanuel Altit, lead counsel.
Defense team of Mr. Blé Goudé.
Good afternoon, Mr. President. The defense of Charles Blé Goudé is today represented by myself, Alexander Knops, counsel, and Mr. Serge Bouillon, legal assistant, and Mr. Blé Goudé is present here in the courtroom. Thank you.
Thank you very much. Can we then go to the office of to the representatives of victims in the case?
Good afternoon, Mr. President. Victims in this proceeding are represented by myself, Paulina Massida. In courtroom today, Ms. Ludovica Vetruccio and Mr. Enrique Carnero Royo. Following from Abidjan, Mr. Brahima Sako. Thank you.
Thank you very much. I note for the records that Mr. Gbagbo and Mr. Blé Goudé are in the courtroom. The appeals chamber is delivering today its judgment in the prosecutor's appeal against the decision of the trial chamber 1 rendered on the 15th of January 2019 with reasons issued on the 16th of July 2019, in which the trial chamber granted the no case to answer motions of Mr. Gbagbo and Mr. Blé Goudé, and acquitted them of all charges. I shall begin by summarizing the background to the appeal. The case arose out of the 2010 and 2011 post-election violence in Côte d'Ivoire. Under the prosecutor's theory of the case, the violence following the election occurred against victims perceived as the then President-elect Ouattara's supporters on the basis of their Muslim faith, ethnicity, or regional affiliation. It was argued that outgoing President Gbagbo, who lost the election, and his inner circle, to which Mr. Blé Goudé allegedly belonged, controlled the state security forces, militia, and mercenaries that carried out attacks allegedly aimed at allowing Mr. Gbagbo to remain in power. In the circumstances, Mr. Gbagbo was charged with crimes against humanity for acts allegedly committed between the 16th of December 2010 and the 12th of April 2011. Mr. Blé Goudé, the former Minister of Youth during Mr. Gbagbo's presidency, was charged with crimes against humanity regarding most of the same events that underlie the charges against Mr. Gbagbo, and one additional incident between the 25th and the 28th of February 2011. On the 23rd of November 2011, Pre-Trial Chamber 3 issued an arrest warrant for Mr. Gbagbo, and on the 30th of November 2011, he was surrendered into the court custody. On the 21st of December 2011, Pre-Trial Chamber 3 issued a warrant of arrest for Mr. Blé Goudé, and he was surrendered into ICC custody on the 22nd of March 2014. On the 12th of June 2014, Pre-Trial Chamber 1, by majority, confirmed the charges against Mr. Gbagbo. On the 11th of December 2014, Pre-Trial Chamber 1 confirmed the charges against Mr. Blé Goudé. Judge Van den Weingart, dissenting. On 11th of March 2015, the trial chamber joined the cases against Mr. Gbagbo and Mr. Blé Goudé, and their trial commenced on the 28th of January 2016. On the 19th of January 2018, the trial chamber held the last hearing in the prosecutor's presentation of our evidence against Mr. Gbagbo and Mr. Blé Goudé. On the 9th of February 2018, the trial chamber issued an order on the further conduct of the proceedings, inviting the prosecutor to file a trial brief illustrating her case and detailing the evidence in support of the charges. It also directed the defense teams to indicate whether or not they wished to make any submissions of a no case to answer motion, or in any event whether they intended to present any evidence in the case. On the 19th of March 2018, the prosecutor filed a mid-trial brief, and on the 23rd of April 2018, counsel for Mr. Gbagbo and Mr. Blé Goudé filed their observations indicating, amongst other things, the suitability of no case to answer proceedings and their intention to trigger that proceeding. On the 4th of June 2018, the trial chamber issued a second order on the conduct of the proceedings, ordering counsel for Mr. Blé Goudé and Mr. Gbagbo to file submissions addressing the issues for which, in their view, the evidence presented by the prosecutor is not sufficient to sustain a conviction. the trial chamber declared that the presentation of the evidence for the prosecutor was closed. On the 23rd of July 2018, counsel for Mr. Gbagbo and Mr. Blé Goudé filed their no case to answer motions, and on the 10th of September 2018, the prosecutor and the Office of Public Counsel for Victims, OPCV, filed their responses. The trial chamber held hearings on the issue in October and November 2018. On the 10th of December 2018, the trial chamber, by majority, scheduled a hearing on continued detention of the accused persons. The hearing took place on the 13th of December 2018. On the 15th of January 2019, the trial chamber, by majority, rendered a decision in open court acquitting Mr. Gbagbo and Mr. Blé Goudé of all charges, and indicated it would provide its full and detailed reasons as soon as possible. 6 months later, on the 16th of July 2019, the trial chamber filed the written reasons for the decision rendered on the 15th of January 2019 and appended to those three opinions the reasons of Judge Henderson, the opinion of Judge Tafusa, and the dissenting opinion of Judge Herrera Kabucha. The trial chamber decided by majority, Judge Herrera Kabucha dissenting, to grant the defense motions for acquittal from all charges against Mr. Gbagbo and Mr. Blé Goudé. Today's judgment by the appeals chamber addresses the appeal of the prosecutor against the acquittals of both Mr. Gbagbo and Mr. Blé Goudé. In her brief, the prosecutor raises two grounds of appeal. Under her first ground of appeal, she argues that the trial chamber erred by acquitting Mr. Gbagbo and Mr. Blé Goudé in violation of the mandatory requirements of Article 74, Paragraph 5 of the Rome Statute, or alternatively erred in the exercise of their discretion by doing so. In her view, convictions and acquittals must comply with specific legal requirements to be found in Article 74, Paragraph 5. She alleges that the trial chamber failed to comply with those requirements. The alleged failure came in the manner of an unreasoned and uninformed oral acquittal on the 15th of January 2019, the prosecutor argued. According to her, the decision was unlawful and cannot produce the effect of an acquittal, and its deficiencies were not cured by the documents filed on the 16th of July 2019. In her second ground of appeal, the prosecutor contends that the trial chamber erred in law or procedure or both by acquitting Mr. Gbagbo and Mr. Blé Goudé without properly articulating and consistently applying a clearly defined standard of proof and indicating a clear approach to assessing the sufficiency of the evidence. In her view, the rules for the no case to answer procedure were not clear to the parties, participants, or within the chamber itself. The prosecutor further brings 6 examples alleging they show that the trial chamber was equivocal and sometimes contradictory as to the evidentiary standards and approaches it followed in assessing the sufficiency of the evidence at the no case to answer stage. According to the prosecutor, the proceedings were effectively ruptured and through the acquittal decision, the prosecutor, victims, and public were prejudiced. Let me now turn attention to certain procedural and preliminary issues. The appeals chamber unanimously determines certain procedural and preliminary issues in the first part of the judgment. These include the scope of the observations of the Office of Public Counsel for Victims in these appeal proceedings, which are then the subject of submissions, in particular from counsel for both Mr. Gbagbo and Mr. Blé Goudé. In that regard, the appeals chamber reaffirms its previous jurisprudence and considers that the OPCV can raise arguments that relate to issues that affect the victim's personal interests and, importantly, remain within the ambit of the prosecutor's grounds of appeal. The appeals chamber has taken into consideration the submissions of the OPCV to the extent that they comply with those criteria. Now, on the first ground of appeal, prosecutor's first ground of appeal, beginning with applicability of Article 74, paragraph 5 of the Rome Statute. The prosecutor's first ground of appeal alleges that the trial chamber violated the requirements of Article 74, paragraph 5 of the statute. The first issue that the appeals chamber needs to decide is whether Article 74, paragraph 5 applies at all in this case, namely whether it applies to the decision taken further to the no case to answer proceedings, which resulted in the acquittal of both accused persons, who are now acquitted persons. It may be noted that Article 74, paragraph 5 of the Rome Statute provides as follows with respect to judgments of the trial chamber. Quote, "The decision shall be in writing and shall contain a full and reasoned statement of the trial chamber's findings on the evidence and conclusions. The trial chamber shall issue one decision. When there is no unanimity, the trial chamber's decision shall contain views of the majority and the minority. The decision or a summary thereof shall be delivered in open court," unquote. The parties and participants make opposing submissions about this issue. The prosecutor and the OPCV submit that it does apply, that is, the provision does apply. For their part, counsel for both Mr. Gbagbo and Mr. Blé Goudé dispute that this provision applies. The appeal chamber notes that counsel for Mr. Blé Goudé emphasizes that there are two consequences of his arguments, that the trial chamber was not bound by the requirement of Article 74, paragraph 5. First, he argues that this appeal is inadmissible in the first place and should be summarily dismissed because the prosecutor cannot bring this appeal pursuant to Article 81 of the Rome Statute, as she has done, given that the decision to acquit is not one that falls under Article 74. Now, what makes that point remarkable is that Article 81, paragraph 1, provides that an appeal may be brought as of right against a decision under Article 74 of the statute, rather than with permission or with leave, to use the legal terminology. The prosecutor, the argument goes, has brought this appeal under Article 81, paragraph 1. In the circumstances of the decision of the 15th of January 2019, the decision could not have been taken under Article 74. Any appeal of it would therefore require the leave of the trial chamber under the necessary provision of the Rome Statute in order for the appeal to be brought before the appeals chamber. Yet the prosecutor did not seek any such leave to appeal in the present case, and he goes without saying that none was granted. Second, counsel for Mr. Blé Goudé argues that as there was no legal requirement for the trial chamber to render its decision under Article 74, the requirements of Article 74, paragraph 5 could not have been breached because those requirements were not binding upon the trial chamber. That interpretation would have resulted in a complete dismissal of the first ground of the prosecutor's appeal, which entirely depends on the application of Article 74. At this juncture in our proceedings today, the appeals chamber recalls and reiterates its previous judgment in the case of Ntaganda, an interlocutory judgment rendered on the 15th of September 2017, not the one of yesterday, in which the appeal chamber held that a court's legal framework permits the no case to answer procedure. This is fully consistent with established procedures in the administration of international criminal justice. The no case to answer procedure is a necessary adjunct to two of the most fundamental principles of criminal law. One is that the defendant enjoys a presumption of innocence. The other is that the burden of displacing that presumption always rests on the prosecution to be discharged on a standard of proof beyond reasonable doubt. The Ntaganda judgment determines that Article 64 was the legal basis for deciding to conduct no case to answer proceedings at the ICC. However, that decision did not address which of the court's provisions apply to a decision that acquits the accused person further to such no case to answer proceedings. For the reasons explained in today's judgment, the appeals chamber finds that judgments of a trial chamber for a full acquittal of a defendant following a no case to answer motion fall entirely within the purview of Article 74 of the statute. This is primarily because that provision is intended to regulate the trial chamber's final judgment that puts an end to the trial, either by way of a conviction or by way of an acquittal. It is true that an unsuccessful motion of no case to answer does not, as such, contemplate a conviction of the defendant and thus does not bring a case to a final conclusion. However, the incidence of the motion is different in the event of a full acquittal of the defendant following a successful no case to answer motion. The case is brought to conclusion and the plea of double jeopardy or nebis in idem, to use the Latin expression, fully attaches. For that reason, such judgment of acquittal fall entirely within the ambit of Article 74, and they are to be fully regulated accordingly, in the same manner as a judgment resulting from a plenary trial. The appeals chamber therefore rejects the submissions of counsel for Mr. Gbagbo and Mr. Blé Goudé. The conclusion of the appeals chamber as to the applicability of Article 74, paragraph 5 is unanimous, but Judge Ibanez and Judge Bosa disagree with some of the reasoning used to reach this conclusion for reasons set out fully in their separate opinions. The remainder of this judgment is taken by the majority of the appeals chamber, with Judge Ibanez and Judge Bosa dissenting for reasons given in their dissenting opinions filed with the judgment. I begin with the requirement of Article 74, paragraph 5. The prosecutor alleges several breaches of Article 74, paragraph 5. She argues that the trial chamber did not comply with Article 74, paragraph 5 because, first, the trial chamber failed to render a decision in writing. Secondly, the trial chamber failed to provide a full and reasoned statement of its findings on the evidence and conclusions. Third, the trial chamber failed to deliver its decision or a summary of it in open court. And fourth, that the trial chamber failed to issue one decision in that the separation of reasons from the verdict breached the principle of one decision and the manner of issuance of the reasons, consisting of three separate opinions, one by each trial judge in July 2019, breached the principle of one decision. In making her arguments, the prosecutor views the decision of the 15th of January 2019 as a stand-alone decision and argues that it cannot be read together with the reasons filed in July 2019. However, it is clear to the appeals chamber that the trial chamber did not intend for its verdict delivered on the 15th of January 2019 to stand alone. It was intended to be complemented by full and detailed reasons to follow. The appeal chamber has assessed whether the trial chamber's decision is, on this basis, consistent with Article 74, paragraph 5 of the Rome Statute. The appeals chamber rejects the prosecutor's argument that the trial chamber erred by announcing its verdict on the 15th of January 2019 with reasons to follow. Whilst trial chambers should ideally deliver both verdicts and reasons concurrently, the very fact that a delay is encountered between the issuance of a verdict and its reasons cannot necessarily invalidate an entire trial process or indeed breach Article 74, paragraph 5. There may, on the contrary, be clear justification for such separation in the particular circumstances of a case, most obviously when the liberty of an acquitted defendant is at stake. The trial chamber in this case, having definitively arrived at its decision to acquit, could not countenance and could not countenance unnecessarily maintaining Mr. Gbagbo and Mr. Blé Goudé in detention for the time it would take to issue the reasons for the verdict. The trial chamber correctly found that the need to pronounce the verdict and thereby release Mr. Gbagbo and Mr. Blé Goudé outweighed the formal requirements of Article 74, paragraph 5, in any expectation that the verdict of acquittal and the reasons for that verdict must always be delivered together. As to the prosecutor's argument that the trial chamber erred by failing to issue the 15th of January 2019 decision in writing, the appeals chamber finds that all the components of Article 74, paragraph 5 of the statute must be issued in writing, both the operative part, being the verdict, and the reasons. Although the judges of the appeal chamber comprising the majority diverge on the question of whether or not the verdict delivered on the 15th of January 2019 met this requirement, the appeal chamber finds that whether or not the decision was in writing is, in the instant case, patently incapable of materially affecting the decision of the trial chamber. As to the prosecutor's argument regarding the inadequacies of the summary given by the trial chamber on the 15th of January 2019, the appeals chamber finds that nothing in the Rome Statute strictly commands the content of any summary to be issued at the same time of announcement of the verdict. What the statute requires is that the trial chamber issue a fully reasoned judgment, whilst the trial chamber's summary in this case was certainly brief. It contained the most important parts of the reasoning. As to the timing of issuance of reasons of the 15th of January 2019, the prosecutor argues that the unity of the decision was broken by the lapse of 6 months between rendering the verdict and issuing the reasons, or by the fact that the time for the delivery of the written reasons was not given, or by both considerations. However, Article 74, paragraph 5 of the statute does not include a time limit within which a decision issued pursuant to that decision, to that provision, should be provided following a trial. Concerning the prosecutor's argument that the trial chamber breached the one decision principle in Article 74, paragraph 5, because the three judges of the trial chamber issued their own individual opinions as opposed to a reasoned statement of the majority, the appeals chamber rejects this argument on its facts. This is appeals chamber by majority. Judges Tafusa and Judge Henderson wrote clearly in concurrence as the two judges that formed the majority of the trial chamber. Further, the reasons issued in July were set out in one document signed by all three judges and formally satisfied the basic understanding of the requirement to issue one decision. Furthermore, contrary to the prosecutor's argument, the trial chamber was not prevented by internationally recognized human rights law from taking the approach it did. It ensured that no prejudice was caused the parties, the victims, or indeed the public by suspending the time limits for appealing the acquittals until the written reasons had been provided and sufficiently keeping the public abreast of developments in the proceedings. To conclude, on ground one, the appeals chamber by majority finds that to the extent that any error had been found under this ground of appeal as to whether the verdict issued on the 15th of January 2019 was filed in writing, this error is patently incapable of materially affecting the decision in this case. Judge Ibanez dissented from that finding of the appeals chamber. The verdict was pronounced in open court. followed by both a written transcript and written press release. And it was later filed in July 2019. It is self-evident that the verdict of acquittal would have been the same had the trial chamber taken the additional step of filing them on the 15th of January 2019. Moving on now to the prosecutor's second ground of appeal. Under the second ground of appeal, the prosecutor argues that the trial chamber failed to properly articulate and consistently apply a clearly defined standard of proof or approach to assessing and commonly agreed upon standard of proof or approach to assessing the sufficiency of the evidence at the no case to answer stage before it actually did that evidential assessment. In particular, the prosecutor submits that by failing to direct itself as to the relevant evidentiary standards, the trial chamber erred in law, and by failing to set out its approach as to how it would assess the evidence before doing so, the trial chamber erred in procedure. As a consequence of the above failures and of such an ambiguous and unclear approach, the prosecutor argues that the trial chamber made several inconsistent and incorrect evidentiary assessments. In particular, the prosecutor argues that the trial chamber's alleged failure to articulate and apply its evidentiary approach is illustrated in the following 3 points. First, by the procedural history of this case, which demonstrated what the prosecutor described as flawed process. Next, by Judge Henderson's articulation and application of an overly rigid and unsupported approach to corroboration, which is in itself a further error of law, without giving notice to the parties. And finally, by the trial chamber's incorrect and inconsistent assessment of several factual matters as set out in 6 examples that the prosecutor submitted as illustrating those errors. According to the prosecutor, each example consists of multiple errors and or inconsistencies that show that the majority's approach was deeply flawed. In light of the prosecutor's argument, the appeals chamber first addresses in the judgment the allegation that the trial chamber failed to set out and agree upon the applicable standard of proof before assessing the evidence. In this regard, the appeals chamber has identified the evidentiary standard against which no case to answer motions should be assessed. Judge Ibanez dissenting. The appeals chamber then determined whether the judges of the majority identified an evidentiary standard, whether it was the correct standard, and whether the standard was commonly agreed upon between the 2 judges forming the majority of the trial chamber. The appeals chamber then considers the prosecutor's argument that the trial chamber erred procedurally, primarily by failing to give guidance to the parties and to the OPCV as to the applicable evidentiary standard before disposing of the no case to answer motions. Finally, the appeals chamber considers the arguments of the prosecutor concerning corroboration as well as the other alleged errors in the assessment of the evidence, which according to the prosecutor resulted from the failure to define and agree upon the applicable evidentiary standard and approach. The appeals chamber has examined the prosecutor's alleged allegations under this ground of appeal, applying the standard of review for legal and factual errors. Concerning the applicable standard at the no case to answer stage, in the event of a motion of no case to answer, the test that guides the trial chamber's decision may be expressed as follows. Upon the conclusion of the evidence presented by the prosecution and on behalf of the victims as appropriate, the trial chamber shall acquit the defendant or, as the case may be, dismiss one or more of the charges where the evidence thus presented is insufficient in law to sustain a conviction on the concerned charge or charges. The foregoing test is fully consistent with the classic test of the no case to answer procedure as applied in both international and national jurisdictions. A proper appreciation of the applicable test should make it wholly appropriate and correct to articulate the standard of proof at the level of proof beyond reasonable doubt and nothing less. The appeals chamber relied on the test set out by the appeals chamber of the ICTY in the Yelasich case, as well as the standard of proof indicated in Rule 130, Paragraph 3 of the Rules of Procedure and Evidence of the Kosovo Specialist Chamber, noting that this was further supported by important authority from national jurisdictions. The appeal chamber considers that it is only when the evidence has satisfied the standard of proof beyond reasonable doubt that it can be said to have been, quote, sufficient to sustain a conviction, unquote, or, quote, capable of supporting a conviction, unquote. Nothing less would do. In the assessment of the evidence for purposes of a no case to answer motion, the trial chamber is not precluded from sensibly weighing credibility and reliability of the evidence thus far presented in order to satisfy the applicable standard of proof. In those national jurisdictions where there is a jury, an agonizing debate is often encountered concerning the propriety of judges entering into assessment of credibility and reliability of evidence in the context of the no case to answer procedure. That concern necessarily arises because of the division of functions between judge and jury in an arrangement in which assessment of credibility and reliability of evidence is the exclusive prerogative of the jury, while the determination of no case to answer is the prerogative of the judge. But that concern does not arise in the circumstances of the ICC. There is no similar separation of functions because there is no jury. Judges have the prerogative of assessment of credibility and reliability of evidence at any point in the proceeding when such an assessment falls to be made. Indeed, a correct appreciation of the standard of proof applicable at the no case to answer stage necessarily entails the assessment of credibility and reliability. This is because no reasonable tribunal of fact, quote, could properly convict, unquote, on the basis of evidence the credibility and reliability of which could not persuade the mind that guilt has been proven beyond reasonable doubt. As to how the evidence should be assessed, the prosecution evidence should be considered at its best, or taken in its best light. These expressions do not mean that the prosecution evidence must be taken at face value or be presumed to have satisfied its forensic objective. The expressions only mean that the evidential assessment will focus on the strength of the case for the prosecution, on the strength of evidence that the prosecution has tendered to prove their case. The appeals chamber will now turn to the question whether the prosecutor is correct when she alleges that the judges of the majority failed to set out and agree upon the evidentiary standard that they would apply when assessing the no case to answer motions. The appeals chamber notes that the prosecutor argues that the judges in the majority did not set out, agree, and therefore direct themselves to the relevant standard before they decided to acquit Mr. Gbagbo and Mr. Blé Goudé on the 15th of January 2019. According to the prosecutor, Judge Henderson's interpretation of the standard was contained only in his own reasons filed 6 months later. The prosecutor argues that Judge Henderson could not have remedied this error by setting out an evidentiary framework 6 months later. According to the prosecutor, Judge Henderson's reasons contained mere afterthoughts, quote unquote, which were developed only after the 15th of January 2019 decision and did not demonstrate that the majority judges had that or indeed any standard in mind at a crucial time before the 15th of January 2019 when they decided to acquit. In order to determine whether the two judges in the majority of the trial chamber defined the evidentiary standard and agreed upon it, the appeals chamber has, in a highly technical legal exercise, reviewed and analyzed the reasons respectively appended by Judge Henderson and Judge Tafusa. The appeal chamber has read it together with the 15th of January 2019 decision and has taken into account the relevant procedural history. In the final analysis, the appeals chamber finds, by majority, Judge Ibanez and Judge Bosa dissenting, that there is no lack of clarity or failure of consensus between the judges in the trial chamber majority as to how to approach the evidence at that stage of the proceedings. They correctly assumed, the trial chamber, that is the appeals chamber correctly assumed, that the trial chamber at a no case to answer stage is not precluded from conducting an in-depth analysis of the evidence, including an assessment of the credibility and reliability of the evidence. To the extent that there is any doubt whether the trial chamber adopted the correct standard of proof, the appeals chamber, by majority, is satisfied that the decision was not materially affected. By adopting the correct approach as to how to assess the sufficiency of the evidence as required at this stage of proceedings, and after a detailed analysis of the evidence, the judges in the trial chamber majority found that the prosecutor's evidence did not meet any standard that could be considered as applicable in a criminal stage. In a criminal trial at that stage. Ultimately, Judge Tafusa and Judge Henderson concurred in their analysis of the sufficiency of the evidence by concluding that the evidence against the defendants was not only weak, quote unquote, exceptionally weak. In the view of the appeals chamber majority, that determines to answer stage before it actually did so. She submits that this error is illustrated by the procedural history of this case, by Judge Henderson's articulation and application of an overly rigid and unsupported approach to corroboration without notice to the parties, and by the trial chamber's incorrect and inconsistent evidentiary assessments as set out in the 6 examples offered by the prosecutor. The appeals chamber understands that the main allegation of the prosecutor in this set of arguments is to be a general lack of clarity as to the conduct of the no case to answer proceedings, in particular as to the applicable evidentiary standard, which is demonstrated mainly in the trial chamber's alleged failure to provide guidance to the parties and to the OPCV during the proceedings leading to the 15th of January 2019 decision. The prosecutor alleges that the trial chamber resisted opportunities to articulate the applicable standard and other evidentiary principles and standards, and that Judge Tafusa, as single judge, declined to provide the clarification when requested to do so. The appeals chamber has assessed the various steps of the no case to answer proceedings before the trial chamber, including the decision rejecting the prosecutor's request for clarification as to the applicable standard. The appeals chamber notes that the parties and the OPCV were provided with ample opportunity to make written and oral submissions on the applicable standard and the approach to assessing the evidence as well as the evidence itself. The appeals chamber by majority considers that the parties and the OPCV were therefore not, as alleged by the prosecutor, prejudiced in the case. The appeals chamber by majority further notes that the prosecutor has not explained what specifically she would have done differently if the trial chamber had given the guidance that it had in mind, that she had in mind. Following an invitation from the trial chamber to file a trial brief illustrating her case and detailing the evidence in support of the charges, the prosecutor was allowed to present her case in detail and explain it fully when filing her midterm brief. As mentioned above, the parties and the OPCV were provided with opportunities to make submissions on the no case to answer motions, including the applicable evidentiary standard approaches to the assessment of the evidence. In any event, the prosecutor was and is at all times aware that she is required to prove her case beyond reasonable doubt and with credible evidence during her turn to present her case. In sum, the appeals chamber by majority, Judge Ibanez and Judge Bosa dissenting, rejects the prosecutor's argument that the trial chamber's failure to give guidance as to the evidentiary standard amounted to a procedural error. The prosecutor also made arguments concerning corroboration. With regard to the prosecutor's allegations of errors in the approach to the assessment of the evidence, and in particular those concerning the approach to corroboration, for reasons fully explained no error in the interpretation of corroboration given by the trial chamber does not consider it necessary to review the prosecutor's argument as to how the trial chamber applied corroboration, and when assessing the evidence, although in a separate concurring opinion, I do make that assessment. As further explained below, the appeals chamber does not find it necessary to review the prosecutor's allegations raised within the 6 examples. And again, I do enter that assessment in a separate concurring opinion. Thus, the appeals chamber does not make any finding as to the correctness or not of the trial chamber's approach to corroboration in these examples. In any event, as noted below, the prosecutor has failed to establish any link between any such error and the trial chamber's alleged lack of a clear approach to corroboration at the time it rendered its acquittal decision. The prosecutor also submitted that the lack of clarity and consensus on the approach of the trial chamber majority to the assessment of evidence led the judges in the majority to make several other mistakes in their evidentiary analysis. According to the prosecutor, this is reflected in 6 examples stemming from Judge Henderson's reasons. In the 6 examples, the prosecutor argues that the trial chamber first erred in how it approached the question of corroboration of evidence. Second, failed to consider the evidence in its totality. Third, adopted an unreasonable and unrealistic view regarding the assessment of witness testimony. Fourth, unfairly subjected evidence of crimes of sexual violence to a heightened level of scrutiny. And fifth, speculated on numbers and estimates outside the case record when seeking to set an empirical benchmark to assess patterns of criminality. According to the prosecutor, the 6 examples are one factor amongst others, illustrating the trial chamber's flawed and unclear approach, quote unquote, to assessing the sufficiency of the evidence. She submits that the trial chamber's unclear approach led to inconsistent and incorrect findings, and that those findings simultaneously demonstrate both the errors and also their consequences. The appeals chamber, by majority, is not persuaded by the arguments of the prosecutor in this regard, Judge Ibanez and Judge Bosa dissenting. To begin with, the appeals chamber by majority finds that when looking at the relevant procedural history, there is neither lack of clarity nor disagreement between the judges of the majority of the trial chamber as to the standard and approach to the assessment of the evidence and the sufficiency of it. In addition, in any event, the prosecutor's submission objections as to the link between the factual examples and her submissions under this ground are unclear. Finally, as regards the prosecutor's submission that the errors that she alleges in respect of the 6 examples could be assessed as factual errors, the appeals chamber recalls that it would have been necessary for the prosecutor to advance arguments showing that no reasonable trial chamber would have come to such a factual finding. The prosecutor has chosen to base her appeal on allegations of legal and procedural errors rather than bringing the alleged errors within the examples as factual errors. At any rate, the prosecutor fails to bring convincing arguments about how the errors alleged within the 6 examples materially affected the decision. The examples include errors and inconsistencies concerning a certain number of factual matters, not all related to incidents that are relevant to both of the accused persons in this case or directly to their individual conduct. The appeal chamber finds by majority, Judge Ibanez and Judge Bosa dissenting, that the prosecutor failed to demonstrate that the trial chamber erred in law or in procedure, and therefore the prosecutor's second ground of appeal is rejected. The question of whether the that when the trial chamber issued the decision of the 15th of January 2019, quote, despite all issues illustrate that the trial chamber's decision of the 15th of February 2019 was not fully informed. 1. The fact that it was not accompanied by summary reasons or a precise timeline for issuing the reasons. 2. The fact that the trial chamber had not completed its assessment of the evidence or reached all conclusions. 3. The fact that there were substantive inconsistencies between the trial chamber's 15th of January 2019 decision and Judge Henderson's reasons. And 4. The fact that there were inconsistencies in assessing the sufficiency of evidence at the no case answer stage within Judge Henderson's reasons. The appeals chamber by majority, Judge Ibanez and Judge Bosa dissenting, finds that the prosecutor has not substantiated her arguments in support of the allegation that the decision of acquittal that the trial chamber rendered on this in January 2019 was not fully informed. The prosecutor's allegations come close to alleging lack of propriety on the part of the 2 judges comprising the majority of the trial chamber. The appeals chamber is careful to note that during the hearing in this case, counsel for the prosecution expressly disavowed such an interpretation of their position. It remains the case, however, that the prosecution is alleging that by their submissions that the 2 judges forming the majority of the trial chamber entered a verdict of acquittal prematurely without fully informing themselves of the evidential considerations that must guide their judgment, the allegation is essentially that these judges had entered verdicts of acquittal before proper deliberations or considering the evidence presented. If this were the case, it would be a grave error indeed, which would affect the integrity and impartiality of the judges. In this regard, judges of the ICC, as elsewhere, must be presumed to act with integrity and impartiality. The appeals chamber would expect evidence of a very clear nature to support such a serious allegation as was made. Now, more to the substance of the allegation. As part of her appeal, the prosecutor makes certain arguments. She first argues that the fact that the 15th of January 2019 decision was not accompanied by summary reasons or a precise timeline for issuing the written reasons show that the majority's necessary reasoning process had not been completed by the time of the 15th of January 2019 decision. Simply put, the appeals chamber considers that these allegations amount to pure speculation. As I already explained in the present case, a summary of the decision was issued, and the fact that it was short does not mean that the trial chamber had not completed its work. Similarly, the fact that a precise time frame for the issue of the written reasons was not given does not substantiate the serious allegation that the trial chamber acquitted both defendants without having been fully informed when doing so. The prosecutor's second argument is that the trial chamber was not fully informed when it acquitted in January 2019 because it had neither completed its assessment of the evidence nor reached all of its conclusions. She raises several arguments in support of this contention. The appeals chamber acknowledges that the presiding judge of the trial chamber said certain things on the 16th of January 2019 that were not wholly clear from the perspective of the duty to assess relevance, probative value, and prejudice. Notably, the presiding judge stated that all evidence that had been submitted would be considered. He also noted that the majority had conducted a more in-depth review of the evidence in this case. In addition, the fact that the trial chamber did not make formal admissibility assessments does not, in any event, inevitably mean that the judges were any less familiar with evidence presented to them during the course of the trial. They stated that they had considered the evidence, and their ultimate conclusion was that there was insufficient evidence on which to proceed. Therefore, it is not possible to conclude from Judge Tafusa's statement of the 16th of January 2019 that the decision of the 15th of January 2019 was not fully informed because, as the prosecutor argues, he had not properly assessed the evidence. The appeals chamber, by majority, rejects the prosecutor's argument for the reasons explained fully in the judgment. The inference which the prosecutor urges the appeals chamber to draw is quite simply too strained and speculative. Judges who have been conducting trials, in some cases trials lasting years, must be presumed to have developed their view of the case based on the appropriate legal principles as the evidence unfolds. The appeal chamber cannot chamber. The appeal chamber finds that the reasoning set out in the written reasons issued in July 2019 was the basis for acquitting the two accused persons in January 2019. Therefore, the prosecutor's argument that the 15th of January 2019 decision was not fully informed is rejected by a majority of the appeals chamber, Judge Ibanez and Judge Bosa dissenting. Now, the appropriate relief. In the present appeal, the appeals chamber by majority has found no error that could have materially affected the decision of the trial chamber in relation to either of the prosecutor's two grounds of appeal. It therefore rejects the prosecutor's appeal and confirms the decision of the trial chamber. Furthermore, the appeal chamber recalls that in its decision on Mr. Gbagbo's request for reconsideration of his conditions of release, the appeal chamber reviewed and revised the conditions on the release of Mr. Gbagbo and Mr. Blé Goudé, revoking some conditions and maintaining others. The appeal chamber hereby revokes all remaining conditions on the release of Mr. Gbagbo and Mr. Blé Goudé as a result of this judgment. The registrar is hereby directed, pursuant to Rule 185, Paragraph 1 of the rules, to make such arrangements as considered appropriate as soon as possible for the safe transfer of Mr. Gbagbo and Mr. Blé Goudé to a state or states contemplated in that rule, taking into account the views of the acquitted persons. As previously stated, the appeals chamber's judgment is taken by majority, with Judge Ibanez and Judge Bosa dissenting for the reasons fully expressed in their respective opinions filed today. But by way of very brief summary, Judge Ibanez is of the view that no case to answer procedure has no place in the court's applicable law. As to the first ground of appeal, she is of the view that Article 74, Paragraph 2 and Paragraph 5 contain important guarantees of justice which the trial chamber breached. And as to the second ground, she is of the view that the majority of the trial chamber applied an incorrect standard of proof and made other significant errors in its appraisal of the evidence. It also fails to inform the parties and participants of the applicable standard of proof. In her view, all these were significant errors of law and fact. And Judge Bosa agrees, for her part, she agrees with the majority of the trial chamber that the no case to answer procedure may be applied in trials before the ICC. If a trial chamber decides to acquit an accused at this stage, the decision has to comply with Article 74. She is of the view that the majority of the trial chamber failed to comply with this provision. Importantly, in relation to the prosecutor's second ground of appeal, Judge Bosa considers that the majority of the trial chamber failed to agree on the applicability of the no case to answer procedure, how and whether to assess all the evidence at this stage, and what the applicable standard of proof was. Judge Ibanez and Judge Bosa therefore would have granted the prosecutor's appeal and would have ordered a new trial. I append a separate concurring opinion on grounds 1 and 2 of the appeal. Judge Morrison appends a separate concurring opinion on ground 1 of the appeal. Judge Hofmaski appends a separate concurring opinion on ground 1 of the appeal. Judge Ibanez appends a dissenting opinion on grounds 1 and ground 2 of the appeal, Judge Bosa appends to this judgment a dissenting opinion on grounds 1 and ground 2 of the appeal. That brings me to the end of the formal part of the proceeding, but as this is my very last judicial function at the ICC, I must take the opportunity to express the words of gratitude of all my colleagues of the appeals chamber, and we do so exclusively to the staff that we have relied upon to do our judicial work. Talking about interpreters, the court reporters in the booths, the technicians who assist us to make things work, security staff, the sanitary staff and building management staff, staff of the transport section who ensure movement of witnesses and defendants, the finance section who make sure that defense counsel paid their fees, and so to other people who work at the court. I could keep going on with a long list of those who make things work, but in the end, it necessarily still will leave someone out unmentioned. Suffice to say, we are extremely grateful. When I served the court as president, I often say that we cannot do this work without you, the staff. But that is not merely a sentiment of pointless grace. The experience of the past few days demonstrates how real that message truly is, and it is in the experience of a certain cadre of court staff that I have not mentioned above. These are the staff who assist the judges in drafting judgments. As I put it in a recent internal message, they moved mountains of physical, emotional, and electronic efforts to get us to the finish line in these last two cases, the one rendered yesterday in Tagenda and the one of today. And they did so in spite of all odds. And to be sure, those odds were myriad indeed, in ways that many would not know. For instance, in addition to everything else that the teams have had to endure, SharePoint is the electronic shared drafting platform, kept on freezing and crashing throughout yesterday, even late into the night, as drafts were being shared and exchanged, slowing down the drafting process to a crawl, an extremely frustrating pace. I know this because I, too, suffered that experience with them in my capacity as the leader of the drafting team. But I did so from the more privileged position of dumping my own frustrations downstream for them to find solutions. Rieko, Odo, and Lucia had to put up politely with my frantic phone calls every 2 minutes for someone to explain why the paragraph auto-numbering function wasn't working and why the review tab in Microsoft Word has simply disappeared. Along with it, the track changes and the accept change and reject change functions. And for several hours yesterday, one key member of drafting team was literally unable to draft because the system crashed. That is to say, even computer itself found it difficult to cope. Of course, SharePoint will say, don't blame me, blame COVID, who made people work from a remote location rather than together so I can function well. But all through all that, the staff persevered well into the night, kept on drafting. still on COVID. One, as he was leaving the office past 11 p.m., came by my office to make sure that I had the appropriate pass to show the COVID patrol so they wouldn't arrest me on my way home. That is all to say, we are extremely grateful, and that little story into the backdrop of the backstory of what we do and go through is simply meant to illustrate the many ways in which staff of this court make things work. Without many knowing it. Thank you. Court is adjourned.
All rise.